आपको नेदरलैंड्स के हेग कोर्ट की तस्वीरें दिखाते हैं, जो इंटरनेशनल कोर्ट ऑफ जस्टिस है, जहां कुलभूषण जाधव मामले में सुनवाई लगातार चल रही है और जो भारतीय वकील है हरीश साल्वे अपनी टीम के साथ पक्ष रख रहे हैं कुलभूषण जाधव के समर्थन में।
But to all human beings and in present context to nationals of sending states. The International Covenant on Civil and Political Rights, which came into force on 23rd March 76 in the preamble states, the recognition of the inherent dignity and of the equal and unalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. Recognizing that these rights derive from the inherent dignity of the human person. It goes on to state that considering the obligations of states under the Charter of the United Nations to promote universal respect for an observance of human rights and freedoms, the parties agree upon the articles. Article 14 sets out what is recognized as the rights of a person in relation to determination of criminal charges. Honourable President and Honourable Members of the Court, I strongly submit that the Vienna Convention is a powerful tool that ensures at the multilateral level, almost at a universal level, the facility of consular access to foreign nationals who have been put on trial in a foreign country. This is based on the recognition of the rights of a national of the sending state to put up a fair defense at the determination of criminal charges in the host state. And this becomes meaningful when he has the benefit of consular access in its various dimensions recognized in Article 36. One of the vital areas of human rights is the treatment of those accused of crimes. The principles of due process expressly recognized in the ICCPR must jurisprudentially be considered to be a universal obligation binding upon all states, erga omnes. Consular access to a national of a sending state charged with a crime in a sending state evolved as a practice and found codification in Article 36 at a time when human rights jurisprudence was in its incunabulum. It was recognized by those who wrote the treaty to be a right without exceptions. They went further and wrote the right not just in favor of the sending state and its consulate, but also in favor of the nationals of the sending, with the universal acceptance of the right to a fair and an impartial trial, and the right to defend oneself against criminal charges, including the right to engage in lawyers of one's choice in a foreign country, as a rudimentary rule of due process. Article 36 becomes a vital cog in the wheels of justice. As was said of the Geneva Convention by this court, so can it be said about the Vienna Convention, that in some respects the principles enshrined were a development and in other respects no more than an expression of the fundamental principles of humanitarian law and diplomacy. These measures were designed to put in place an instrument essential for the effective cooperation in the international community and for enabling states, irrespective of their different constitutional and social systems, to achieve mutual understandings to resolve their differences by peaceful means. In a judgment delivered in 2010 in the Diallo case, this court considered a challenge to the actions of the Democratic Republic of Congo in respect of detention and expulsion of the National Republic of Guinea, in the backdrop of rights and the obligations under the ICCPR.
तो एक एक झूठ का पर्दाफाश कर रहे हैं पाकिस्तान के खिलाफ हरीश साल्वे, और उनका साफ तौर पर कहना है कि पाकिस्तान जाधव पर प्रोपेगेंडा बनाया हुआ है। इस बड़ी खबर के साथ लगातार हम बने हुए हैं। फिलहाल रुकना होगा एक झूठ।